How can competition policy ensure effective utilization of economic resources and potential? To deliberate on this, I now invite our distinguished panel, comprising Shri Dhanendra Kumar, Srimati Sangeeta Verma, and Shri Augustine Peter. Shri Dhanendra Kumar is the former and first chairman of the Competition Commission of India. A 1968 batch IS officer, he's played a pivotal role in establishing India's market regulator, recruiting and training staff, and initiating the enforcement of competition laws and the review of combinations. His leadership has significantly influenced India's regulatory frameworks in various sectors. He was the executive director of the World Bank and has served as secretary to the Government of India in critical ministries like defense production, road transport and highways, and culture. Srimati Sangeeta Verma is a former member of the Competition Commission of one batch of the Indian Economic Service. She brings with her over 37 years of experience in administration, regulation, and policy making across various sectors in both the Government of India and the Government of Uttar Pradesh. Throughout her distinguished career, she has contributed significantly to a range of policy areas. She has also served as an acting chairperson of the Competition Commission of India. Shri Augustine Peter is a former member of Competition Commission of India. He has also served as Director General in Ministry of Petroleum and Natural Gas, Economic Advisor in the Department of Commerce, Economic Advisor to the Competition Commission of India, Director of the Trade Policy Division at Department of Commerce and Head of Transport Unit Project Appraisal and Management Division in the erstwhile Planning Commission of India. A banker, having worked with the State Bank of India and the Indian Bank, he was the Indian delegate at the United Nations Industrial Development Organization. He was also the lead consultant with the government of Nepal and prepared draft industrial and investment policies for that country. The session will be moderated by Shri Augustine Peter. So may I now request you to initiate the discussion.
Thank you very much. First of all, I should congratulate Rakhav for taking this initiative. And it was a very enlightening first plenary session where a lot of issues, current issues have been put in perspective. Now, competition commission, competition law, it is slightly distinct from the sectoral regulatory context. While sectoral regulators, they regulate ex ante, they are in-market regulators. They provide rules of the game, they set, and according to which the players in the sector has to act. Competition law is basically competition is an off-market regulator. The rules of the game are basically the rules related to market economy. That means the players in the market should compete. They should not act in concert. They should not be using their market power to the detriment of the consumers, as also to the detriment of the players, other players in the market, and also to the detriment of competition in markets. So that is the basic issue. And there is also the principle that the sectoral regulators, they are also there to, when competition is not feasible or possible or is at a high cost because of technological reasons or other reasons, the sectoral regulators are there. They have to gradually take the sector more and more towards competition. There have been instances also when, after taking the sector towards full competition, sectoral regulators have withered away. There have been instances. So the intention is that the sector concerned which is not regulatable, at a particular point of time, they have to be taken more closer to competition, more and more. So specific efforts have to be taken. Two instances. For example, there are two reasons why competition is made possible in sectoral regulators. One is there are some technological innovations. For example, mobile telephony came, and then competition became much more possible in the telecom sector. Again, unbundling, the concept of managerial innovation means generation, transmission, and final distribution. Generation competition is possible. Earlier it was thought that competition is not possible in the electricity sector. Now, yes, generation, there is competition possible. Transmission, competition possible by ensuring that there is access, non-discriminatory access. Yes, issues remain in the final last stage distribution, this thing. So that is there. So that is one issue where competition and regulation, there is some distinction, but they are converging in the objectives. Now, I will just come to the.
Leave in next 5 minutes.
Yeah, you are, yeah.
5 minutes I'll leave.
You will leave. Oh, achha, okay. So I think Dhanendra Kumar ji, I think he has got some issue. He has to leave. So I think we will hear from him first, and then we will continue. So then he will not be here for the question answer also. Yeah.
Thank you very much, Augustine. Well, first of all, my heartiest congratulations to my friend Raghav and to his Cunsult group. I'm very happy to have this event here today and thank them for inviting me. I'm sorry I have to leave for an unavoidable personal engagement, which is there half an hour away at 10:45. So I'll leave in the next 5 minutes at best. I'll just share a few thoughts and any question answers. We have experts. Augustine Peter has worked with me when I joined as first chairman. He was the Director General, knows everything about competition law. And Sangeeta ji is also a prominent economist, apart from having been the acting chairman of the CCI. Well, friends, I would just like to start by a few anecdotes and just 1 or 2 points. Firstly, when I joined as chairman of the CCI, that was 28th of February 2009, and it appeared in the newspapers next day. Lot of friends called me asking me, hey, you got a brand new assignment, what do you do? Do you conduct competitive examinations? So there was not much awareness about the Competition Commission at that time. Gradually we conducted competition advocacies and so on, and then of course, not because of that, but because of the cases taken up by CCI, people came to know what is CCI. Some people told me that, well, we had enough mothers-in-law regulators breathing behind our back, and why do we have another mother-in-law? So I told them it's a friendly mother-in-law which will make things easier for you. But anyways, that was the time in 2009. Let me also go back in the history and tell you that if you trace the history of British colonization in India, the genesis came because of the grant of monopoly trading to the East India Company. At that time, the East India Company traders came with a letter from the British monarch and called on the Emperor Jahangir, gave him some gifts and so on, and procured from him monopoly rights in spices and so on. Gradually, they consolidated their economic power through the trading and then the military power, and then the rest is history. So monopoly can lead to a lot of undesirable consequences, and it was in that context that after independence, when India started its journey towards the free India, then they enacted MRTP Act, Monopoly Restrictive Trade Practices, and subsequent legislations. Then came the Competition Commission, where the idea was not so much regulation, but the promotion. And if we look at the preamble of the Act, The preamble of the act said this is an act to provide economic development of the country for the establishment. This was the purpose. Main purpose was the economic development of the country, and to set up a commission which is CCI, and they gave 4 functions to CCI. One was to prevent practices having adverse effect on competition, then to promote and sustain competition, and third was to protect the interest of consumers and to ensure freedom of trade carried on by other participants, and so on. For paucity of time, I wouldn't like to go into details. The subsequent amendments, the deal value thresholds, and settlement and commitment, and so on, why the reasons, and so on. In fact, I was reading newspapers yesterday. Google could be the first company to come forward for the settlement for one of the cases which is pending in CCI. I don't know. I mean, I just read in the newspapers. CCI has come up with a number of innovative features in their enforcement, which included the green value, the green channel, and also time-bound decisions in many cases. Altogether, the philosophy of the CCI in its enforcement today is that there should be as much as possible self-compliance. So the enterprises should be made aware of the various provisions and how they can resort to compliance voluntarily. And that's why there are a number of incentives also given for compliance. So friends, I would only like to say that today is an era where this one of the most important regulators in the country, which is considered to be the regulator of regulators, is active and also encouraging people to take up voluntary compliance measures. Even the filings can be done directly, and there are booklets available. You don't even need lawyers, but still, lawyers are needed. In any case, it's a question of bread and butter also. Yet, if some companies wish to, SMEs in particular, wish to proceed as such, they can do it. I'll end by just one personal anecdote again, because Augustine mentioned about telecom. I used to be Additional Secretary Telecom from 98 to 2002 and Secretary of the Telecom Commission at that time. So, lot of action was taken. DOT was dismantled, BSNL came, this, that, and so on, and we had the migration to the mobile telephony and all that. At that time, earlier, people used to come to us for getting telephone connections and lot of sifarish and so on. Later on, after this was dismantled and competition was introduced, it was different. Now, at that time, I remember one of our former cabinet secretaries used to call me every Friday. Dhanendra, and I was his junior, he was my boss earlier. Dhanendra, my telephone is again out of order. He was staying in Noida. So I said, sir, give me the number, I'll get it repaired. So he gave me the number, I would get it repaired. Every Friday, he would call me, and this happened 3-4 times. After that, he stopped calling me, so I was very happy that things seemed to be okay. So after some time, I met him somewhere in a social function. I can even tell the name, Mr. PK Call. So I said, sir, is it all right now? He said, yes, I've entered into understanding with the local officials. I said, what is that? So ये local lineman को सब लोग देते थे lane में सब, तो मैंने भी कुछ शुरू कर दिया. मैंने कहा, sir, the former cabinet secretary, the top bureaucrat of the country, has to pay for getting his line running. It's a shame for us. Can I mention it the next meeting of the Telecom Commission? He said, by all means, I'll send it to you in writing. And that letter is still with me. So whatever did not happen at that time by regulations, by enforcement, happened with competition, with the commission, with the competition. So competition can bring in lot of good results if enforced properly, and it can also bring in economic democracy where everybody is equal and people are vying for your custom. So with these words, friends, I will have to rush because I really can't wait, and my two friends on my left and right would be able to take care of the rest and also answer your questions. Thank you very much once again, Raghav. Thank you. I'll take this bottle for the rest. Thank you so much, Sangeeta ji. Thank you, Augustine.
Thank you very much, Dhanendra Kumar ji. Now I think basically my work is to put in perspective what are the major current issues that are up as far as competition commission or competition law is concerned. See, the digital space has overwhelmed the whole world. We know that the digital firms have replaced the earlier natural resource firms like oil firms and all. With the result, we have seen that Competition Commission of India, as it progressed, maybe 16, 17 onwards, a number of cases are coming as regards digital area. For example, in the case of Google and many other cases. So digital, handling digital, it is a different cup of tea. First of all, digital, what happens? The scale, as the economies of scale, or they are all large firms, and they have increasing returns to scale compared to the decreasing or falling returns to scale. Second, their market power is such that they are able to dictate terms to the market invariably. And non-price competition is an area where, again, which is distinct from the price-based competition which is there in the non-digital or bricks and mortar. So a number of issues have cropped up. So there is a discussion which has been mooted, and in fact European Commission has already put in place ex-ante regulation of competition law, digital market. There is a law already present there, and we had a competition law review committee which submitted the report in 2019 July. So they told that yes, there is an issue, but there is no need for a separate law. However, the Parliamentary Standing Committee on Finance, they came with a recommendation that it is essential to have an ex-ante regulation. Yes, government wanted it to be looked at in more detail, and there was a committee on digital market headed by the Secretary of the Corporate Affairs. They again came with a report recently which is recommending that there should be ex-ante regulation. So this is creating bit of a discussion going on, and really there is an issue which I think, so that is one issue which is present before as far as competition law is concerned. The second one is the interface between competition law and sectoral regulators, competition authority. Very ably and in a very succinct way, Rajiv Kumar in the morning put that in perspective. And the third issue, which is again about how, because Competition Commission of India has got an authority to take up suo motu cases, but how to bring such cases into, because there is one way, that is market studies and advocacy. So, and the fourth issue related to the objectives of competition law, because as the title shows here, that is basically is regarding utilization of economic resources, market efficiency and all. But there is a new elephant in the room, that is sustainability. Because everywhere in the world, everybody wants to fire on all cylinders as regards sustainability. Competition law is also tried to be brought in the picture for building sustainability. So whether to dilute the pristine character of competition law to include extraneous, not so extraneous, but other factors into the picture. So that is another issue which is also staring us in the face. So this is, and one more which we don't have time, that is evolution of jurisprudence, which is very, very slow in competition law. Now, without taking more time, I am turning to Sangeeta ji basically to speak her mind, whatever in her mind regarding the interface between sectoral regulators and competition authority. Please.
Thank you, Augustine. That is a very interesting and alive question, as was more than evident from the discussion in the morning in the panel today. But before that, I want to congratulate Cunsult and Mr. Raghav Chandra for organizing this conference on regulatory issues and for getting so many regulators together in a single room. The issue that Mr. Augustine just put to me was inter-regulatory interface, and I don't think this kind of thing has happened before. So many congratulations to you, Raghavji, for bringing all the regulators, or at least ex-regulators, here together on one forum. This is a long-standing challenge, and it has become even more so in recent times. And we've heard this in the morning. They've been likening, despite the very few women in the room today, the women imagery amongst the speakers has been the flavor of the day. Mr. Dhanendra Kumar likened the regulators, the multiple regulators, to the mothers-in-law. Rajiv Kumar Sahab, my dear friend Rajiv Kumar, likened them to the many married wives of the government, be that as it may. So this has been a challenge, and in recent times, let me go again, step back a wee bit. And at the time of the enactment of the laws, government envisaged, the legislature rather envisaged, that there would be a conflict. In India, we have many robust sectoral regulators, and we were bringing in a competition regulator for the market, for maintaining and for promoting and sustaining competition in the market. And this was a cross-sectoral regulator, across sectors, across government, across private sector. So they realized that there would be a likely conflict of interest, conflict of jurisdiction. So government did create at that time a mechanism within the law, within the Competition Act, whereby the regulators, the competition regulator and the sectoral regulators, could make a reference to each other should there be some issue on which they are deciding before, in proceedings before them, which are likely to be contrary to the act which that specific regulator is, under which that specific regulator is acting. These are known as sections 21 and section 21A, under which say, if I have, as the competition regulator, if I have an issue before me where it's likely to be contrary to some of the provisions of the act of, say, the TRAI, I can make a formal reference. The CCI may make a formal reference to the TRAI and obtain their opinion. That opinion then can be taken on board, and the competition regulator can proceed as they think fit. And likewise, the other way around. The other regulator can also make a reference. What was happening was this trigger was very high. It was only if there was some provision that was contrary to the particular statute which that other regulator was acting under, or was governed by. This has been loosened, or the scope has been broadened by the Competition Amendment Act 2023. The Competition Amendment Act, the amendments have been spoken about in a very big way in the morning also, and people have been, Mr. Dhanendra Kumar spoke about, which is in the newspapers in a big way, commitment and settlement amendments that have come in, the leniency plus arrangements that have come in, but very little is being spoken about this very interesting facilitation of inter-regulatory consult. And that is that they have removed that you can make a reference, each regulator can make a reference to the sectoral regulators can make a reference to the Competition Commission of India, or the CCI can make a reference to the sectoral regulators. They have removed if a provision is contrary to the provision in that law. Now they have made it possible on any issue, on any provisions of the law, a reference can be made by these regulators. So they made the whole consultation process easier. So now if we try and figure out where are the conflicts, what is happening is that so the issue is, does CCI have jurisdiction? The answer is yes. Barring sovereign functions, CCI has cross-sectoral jurisdiction. Where does jurisdictional conflict arise? Because every sectoral regulator's statute also has certain matters, certain issues which impinge or which mention or blur the lines between what exactly is completely Competition Commission's remit and what can be their remit. So, for example, the Insurance Regulatory Development Authority, their regulations say that IRDA will regulate combinations and mergers in the insurance sector. That is an area which was otherwise attributed to the Competition Commission of India. TRAI says that they will look into, the TRAI Act says that they will look into abuse of dominance matters in the telecom industry. So these blurring of lines have led to jurisdictional conflicts. They have led to a scenario where a resolution has to be found through a court of law. Things have gone to courts of law recently. On deciding on a matter of patent rights and the competition law, the Delhi High Court has ousted the jurisdiction of the Competition Commission of India on patent rights and design of IPR. In another matter, under the Bharti Airtel, when there was a cartel allegation against Bharti Airtel and Voda Idea Phone by Jio, the court decided that, okay, taking Rajiv Kumar Singh many married wives, so eventually Supreme Court decided that, okay, this issue can be decided both by CCI and by the concerned sectoral regulator, which is TRAI, but they will do it they will do it sequentially, which means unlike the last married wife, it is the more competent, it depends on which wife has what competence, and they will take it up like that. So what the Supreme Court said was that first the matter will go to the TRAI, which will decide on the technical issues and decide if there is a competition matter, and then refer it to the Competition Commission of India. So this became a sequential jurisdiction in a manner weakening the ability of the Competition Commission of India to take up this issue, which was a pure competition matter. So these issues will continue to come up. So we have to now think in terms of going forward. This creates a lot of this kind of interjurisdictional dispute between regulators or brought up by the parties, creates a lot of difficulty for businesses. It harms businesses in the sense that they are caught between the planks of numerous regulatory orders. It hurts the economy because very many players in the market then do a regulatory arbitrage. They will go to one regulator for an order and they'll go to another regulator for an order, and they will delay the process of resolution. So it is harming the parties, the players in the economy. It is harming the economy as a whole. A solution has to be found. A solution has been found to the extent that there is an ability within the Competition Act for regulators to speak to each other. The bar was very high. That bar has been lowered under the Competition Amendment Act 2023. The regulators can now actually pick up and dial each other up and talk to each other on any issue in a proceeding before them which relates to another statute. It does not necessarily have to be contradicting the provisions of that statute. After this, what happens? What is the next thing? We have a jurisdictional issue. We have decided, we have been able to talk to each other. We have spoken to each other. Me and TRA speak to each other. Me and some others speak to each other. But we are not on the same page. How does that resolution occur? Is there any mechanism for resolution? At this point of time, and that is something probably that Cunsult can bring out a brief on and take it forward later, that is just a suggestion from me, that is there a mechanism for resolution once the regulators have actually spoken to each other? There is a model, to my mind. I'm not very clear or on the contours of that model, but it exists, and I think since former Chairman SEBI is here and whole-time member SEBI was here, they may have a better idea. In the financial sector, there is a FSDC, the Financial Sector Stability and Development Council, chaired by the Honorable FM, and it has all the financial sector regulators in it, the IRDA, the SEBI, the PFRDA, and RBI, and all the relevant government departments of the finance sector. Within that particular council works through subcommittees. Within that, there's an inter-regulatory technical group. where one of the functions or mandates of that inter-regulatory technical group, as I understand it, is to actually resolve inter-regulatory issues. Rajiv Kumar Saab mentioned in the morning ULIP, and he said his dear friend Debashish Panda, who was heading the Insurance Regulatory Authority, and SEBI had a dispute about that as to who would regulate that ULIP element, because ULIP is partly insurance and partly investment. And that issue was resolved within the FSDC. And satisfactorily to the benefit of the eventual or the end consumer. That is something which, that is a resolution mechanism in the non-financial sector on the lines of the FSDC can probably be thought about and taken forward in the times to come. And this is very, very important as we move towards a digital, why move? As we are in the midst of a digital age, as my friend just said. Because digital players are into many markets and they are regulated by several regulators simultaneously. They will have the information technology regulator, they will have the data protection regulator, they will have the telecommunication regulator. Their products are far more complex. I forget who mentioned in the morning, but I think Tyagi sir mentioned that, or maybe Mr. Raman mentioned that products have become very complex. Businesses have become very complex. They are all now regulated by multiple regulators. It's very important if we are to move forward smoothly to be able to resolve this inter-regulatory interface and dispute and have a resolution mechanism for it. So with that, I just wanted to leave this thought that we should think in terms of, as we cover, this is a very, very erudite room, highly knowledgeable people here, to be able to take forward a mechanism for resolution of jurisdictional and, apart from courts, jurisdictional and decision disputes for non-financial regulators. And since CCI is an overarching market regulator, there is also, and it should be the case, that CCI also becomes a member of the FSDC. And the FSDC, the CCI and the financial regulators get to talk to each other. With that, I just want to finish on this point with the small thing that although the facility of talking to each other under the statute existed, but it was so difficult, as I said, the trigger was so high. The trigger for starting off a conversation was so high that in the 5 years that I have been there, we have made a total of 4 references to other regulators. So obviously that relaxation was needed.
Thank you very much, but I think we don't have time to discuss all that. Only for the sake of formality, one question we can take. Anybody has any question? Otherwise, we will conclude. Yes, please.
Just now the issue of predatory pricing has become a very common problem across sectors, and especially in the digital space. And that's something, given the increasing returns to scale and all, it is very difficult to do it because companies just want to...
Can you introduce yourself also?
I'm a professor of economics at MDI. And I teach the regulatory course. That's why I thought I'll get an insight from what is the regulatory thinking on those lines. And that's becoming a very serious issue in many sectors.
Not regulatory thinking on predatory pricing.
Yeah, because you can kill the competition, isn't it?
Yeah, that is actually CCA has been taking action. There is a law is very clear on that. If you are a dominant player and you are trying to, there are few criteria set out. That is, you are a dominant player and with the intent to eliminate competition or competitor. If you are pricing, then that CCA take action. So that is very clear. I don't know if you have any specific point regarding that.
I mean, just look. Otherwise, I'm looking around and seeing nothing much is happening. I'm just saying the practice versus the law. I mean, there seems to be a lot of gap. That's the.
So predatory pricing has been. You have anything to add? So otherwise, CCI, the law is very clear. You have to be dominant. Dominance is defined very specifically in the Act. That is, you are.
Let me give 2 examples. Amazon is a very classic example, which does predatory pricing and decimated all the others. Like bookstores are closed completely. There could be a lot of other examples. I can just go on and on because there are multiple.
That you are speaking about deep discounting. Yeah. So in the case of digital, yes, the commission is and the competition law in the world as a whole is gradually trying to come to grip with the reality. Because non-price competition is there, they are dominating the market, and there is a transition from bricks and mortar to the digital. Yes, so there is an issue which authorities all over the world are grappling with. Yes, you are right. In the case of digital, there is an issue and the modalities are being worked out. That's why the proposal for ex-ante regulation is coming. They are planning, as per the proposal, they are planning to list certain firms which are basically significant in the market. They will be listed and notified, and they are not supposed to do deep discounting. They will be prohibited per se ex ante. This is the proposal which is before. Actually, Parliamentary Standing Committee has proposed, and the Committee on Digital Competition, they have also recommended. Government is mooting that, government is contemplating what to be done. So that is the process as it is. Anything can happen anytime. Okay, thank you.
You wanted to add something?
Thank you very much.
No, I think he has covered it. He has covered it. It was, she's asking whether I had anything to add. I won't, because she's running really short of time and there's another panel meeting. Thank you so much. We can always discuss later.